Mr. Brannigan, tell me about supplemental jurisdiction.
Supplemental jurisdiction, I am having trouble remembering that term because it does not come up in criminal practice very much, but I believe it's
It's going to come up in federal district court
Absolutely.
every other Thursday.
And I will certainly carefully research any issue that were to come before me if I'm
It used to be
confirmed.
called pendant jurisdiction.
What's up, everyone? Today, we're diving into a fascinating Senate exchange that touched on religion, workplace rights, constitutional law, and even class actions. It's a sharp mix of legal questions and nominee responses, and I've broken it all down into 10 key moments you'll definitely want to hear. Stick with me, and don't forget to smash that subscribe button if you enjoy clear breakdowns of complex topics like this.
Thank you, Mr. Chairman. I'm sorry, I can't see that far.
Bragdon, me?
Who wants to volunteer? All right,
Senator, I would be happy
Let's
to
just
go
start in the
first.
middle and we'll work to the end. Tell Mr. Also,
Orso, yes. Thank you,
I'm
Senator.
sorry, I really can't. I guess I need to get new glasses. Mr. Orso, let's suppose, imagine this situation. Small printing company, they manufacture envelopes, stationery like that sort of thing. 20 employees, small operation. They take customer orders, go in the back, print the stuff. They wear uniforms because the owner wants to promote his company with the company logo. Employee shows up one day in uniform, but she's wearing a burka. And the owner says, you can't wear a burka here. And the employee says, yes, I can. And the owner says, you're fired. Tell me how you'd analyze that case, what questions you need to know, who would win, who would lose, according to Supreme Court precedent.
Sure. I would likely look first to Title VII of the Civil Rights Act of 1964, since
That's
it's an
correct.
employment case.
And what's Title VII say?
It says that a person cannot be discriminated against in employment on the basis of race, color, national origin, religion,
Right.
gender. And then I would apply the facts of that case, pursuant to
What
any-
facts would you have to know?
I'd have to know if the wearing of that burqa was indicative of any potential religious, closely, sincerely held religious belief. And then if so, would analyze it from there.
What if the employer said, my customers won't like it? Is that a justification?
I don't believe that would be sufficient justification to discriminate against someone based on religious belief. I think you'd have to take into account whether the employer is providing any type of accommodation that allows for that person to.
What if
to
the
work there.
small business owner said, it's dangerous? The employee might get the burqa caught in the manufacturing apparatus.
I think I would have to look at the case law if there's anything similar on that, but my instinct is that, in terms of protecting the safety of employees is a valid concern of an employer.
Okay, fair enough. David, I really
Bragdon.
can't see. I need to do
It's
something. but-
Mr. Bragdon.
David
Mr.
Bragdon, thank you.
Mr. Brannigan, tell me about supplemental jurisdiction.
Supplemental jurisdiction, I am having trouble remembering that term because it does not come up in criminal practice very much, but I believe
It's
it's
going to come up in
jurisdiction.
federal district court
Absolutely.
every other Thursday.
And I will certainly carefully research any issue that were to come before me if I'm
It used to be
confirmed.
called pendant jurisdiction. Does that help?
But I think it's jurisdiction that builds on jurisdiction. I'm thinking it builds on jurisdiction of another party who's already properly before the court. But I don't specifically remember, Senator Kennedy.
Okay. Do you know?
Senator, I would say that that is my understanding as well, and I don't have too much to add in my years as an AUSA. I haven't been working on that recently.
Who knows the answer? What's turn your
This
mic
is
on for me,
Judge Rodriguez, and so I am a sitting U.S. Magistrate judge right now, so I think that I'll step in for the panel. There was a recent Supreme Court case on this, so supplemental jurisdiction is when the court would have original jurisdiction over some sort of federal question, but then there is a state question, and so that's where the court can exercise its discretion over supplemental jurisdiction. A lot of times where that comes up is if something gets, the court could get divested of its jurisdiction if a plaintiff dismissed everything, all of the federal claims. And so it goes back to a jurisdiction issue, and that's what you would be normally looking at.
Okay. Let me go back to Mr. Rousseau. How do you amend the Constitution?
The first scenario came from a senator who posed a tough workplace case. Imagine a small printing company with about 20 employees. They all wear uniforms with the company logo. One day an employee shows up wearing a burka as part of her uniform. The boss says, "You can't wear that here." She insists she can. He fires her. Now, under Title VII of the Civil Rights Act of 1964, employers cannot discriminate based on religion, race, gender, or national origin. The nominee explained that the key question is whether wearing the burka is tied to a sincerely held religious belief. And when the senator asked if customer discomfort was enough reason to ban it, the answer was clear: no, that's not a valid justification. However, safety concerns could be considered legitimate, if, for example, the burka posed a hazard around the printing equipment. The senator then tested the panel with a question about supplemental jurisdiction. One nominee hesitated, but a magistrate judge stepped in and explained, "Federal courts can sometimes extend jurisdiction to related state law claims when there's already a federal question involved." Pretty technical, but important. Next came the Constitution. When asked how to amend it, the nominee pointed to Article 5, requiring 2/3 approval either from Congress or from state legislatures. A reminder of just how high the bar is to change the nation's founding document. The senator moved on to the difference between preliminary and permanent injunctions. Here's the breakdown. A preliminary injunction happens early in a case and requires showing things like irreparable harm, a likelihood of winning, and balance of equities. It basically freezes things while the case plays out. A permanent injunction, on the other hand, comes after the case is decided. At that point, the question is no longer about likelihood, but whether the plaintiff has actually succeeded on the merits. The nominee added that what counts as merits depends heavily on the kind of case and the law behind it. Finally, the senator pressed them on class actions. Under Rule 23, a few plaintiffs can represent a much larger group if certain standards are met: numerosity, commonality, typicality, and adequate representation. That's how huge lawsuits like those involving consumers or employees can move forward as one big case instead of thousands of individual ones. So there you have it, 10 big takeaways from this Senate grilling, covering everything from religious rights in the workplace to federal jurisdiction, constitutional amendments, injunctions, and class actions. These hearings show just how wide-ranging and challenging legal knowledge can be for nominees. If you found this breakdown helpful, hit that like button, share it with a friend who loves law and politics, and of course, make sure you click that subscribe button so you don't miss the next deep dive. Thanks for watching, and I'll see you in the next one.